Ladies and gentlemen, I invite you to continue to stand for the playing of the national anthem on steel pan by Mr. Darrell Reed. You may be seated. The Honourable Mr. Justice Ronnie Boodoosingh, Chief Justice of the Republic of Trinidad and Tobago, and Mrs. Arbeline Boodoosingh, members of the Cabinet of the Republic of Trinidad and Tobago, members of the Diplomatic Corps, Mr. Justice Winston Anderson, President of the Caribbean Court of Justice, judges and judicial officers of the Judiciary of Trinidad and Tobago, our 2026 distinguished lecturer speaker, Mr. Justice Allan Mendonça, Justice of Appeal retired of the Supreme Court of Trinidad and Tobago, and Mrs. Lydia Mendonça, members of the Parliament, members of the Board of the Judicial Education Institute, heads and members of sister courts, retired judges and judicial officers of the Supreme Court, permanent secretaries, representatives of the Trinidad and Tobago Protective Services, representatives of the legal fraternity and justice sector of Trinidad and Tobago, representatives of the state, private sectors, and academia, representatives of court administration, of judiciary, members of the media, other distinguished guests. Good afternoon. I am Genevieve Melanie Julian, Executive Director of the Judicial Education Institute of Trinidad and Tobago. It is my distinct honor to present this afternoon's chair of the proceedings, whose leadership of the JEITT reflects an unwavering commitment to judicial excellence and the continued development of the judiciary. Under Justice Gillian Lucky's stewardship, the Institute has expanded its educational programs, strengthened meaningful regional and international partnerships, and reinforced its reputation as a leading institute for judicial education in Trinidad and Tobago and the wider Caribbean. Justice Lucky has long championed the principle that the judiciary's strength lies not only in the quality of its decisions, but also in its dedication to learning, purposeful mentorship, and investing in its own. That philosophy has shaped the work of the JEITT and fostered a culture of professional growth, collaboration, and excellence across the judiciary. Ladies and gentlemen, please join me in extending a warm and distinguished welcome to our chair for this evening's proceedings, the Honourable Justice Gillian Lucky, Justice of Appeal and Chair of the Judicial Education Institute of Trinidad and Tobago.
Thank you very much, Ms. Julian, Executive Director of the JEITT. I did ask you to be no more than 1 minute. and I think you were well within your time. If there was any need to extend, we have persons who know well about how you ask for an extension of time. The Honourable Mr. Justice Ronnie Boodoosingh, Chief Justice of the Republic of Trinidad and Tobago, and Mrs. Allan Boodoosingh. Senator the Honourable Mr. Darrell Allaha and Mrs. Nisha Allaha. Members of the Cabinet of the Republic of Trinidad and Tobago, members of the Diplomatic Corps, Mr. Justice Winston Anderson, President of the Caribbean Court of Justice, and members of the CCJ, judges and judicial officers of the Judiciary of Trinidad and Tobago, our 2026 distinguished lecture speaker, Mr. Justice Allan Mendonça, Justice of Appeal retired of the Supreme Court of Trinidad and Tobago, and Mrs. Lydia Mendonça, members of Parliament, members of the board of the JEITT, heads and members of sister courts, retired judges and judicial officers of the Supreme Court, permanent secretaries, representatives of the Trinidad and Tobago Protective Services, representatives of the legal fraternity and justice sector of Trinidad and Tobago, representatives of the state and private sectors and academia, representatives of the court administration of the Judiciary of Trinidad and Tobago, members of the media, staff of the JEITT, and all persons in this room and viewing online who each of you we consider to be distinguished. I was a bit anxious this afternoon when England was playing DR Congo. Many of you may or may not know that our distinguished lecture speaker supports one of those teams. So when they were down by 1 goal, I said, I wonder if this would be an excuse for him not coming. I'm very happy that Kane and whoever else came to the rescue. And when I checked, England won 2-1. And I did say a prayer for them, although they're not the team that I support at this point. Go Argentina, but I'm very happy for that result. The Distinguished Jurist Lecture Series, DJL as we call it, of which this is the 11th, provides the Judicial Education Institute of Trinidad and Tobago with an opportunity to feature an individual who is recognized for their significant contribution to the administration of justice. Several names were placed before the president of the JEITT, who is our Honourable Chief Justice Ronnie Boodoosingh, and the board members, in order to determine who should be asked to stand in the spotlight of the DJL 2026. The unanimous view was that the Honourable Mr. Justice Allan Mendonça, Justice of Appeal now retired, would be the perfect choice. I know that despite his love for professional lawn tennis and football, Justice Mendonça is not a competitive person. But let the record reflect that you, sir, were our first and only choice, and we were truly honored when you accepted the invitation to be our distinguished jurist. The judicial track record of Justice Mendonça speaks volumes about his amazing legal acumen. I always knew that he was had a no-nonsense approach to his work, because I worked for 1 year with the law firm de Nobrega and Company when he was a partner at that firm. When the appeal court judges were placed in 3 groups, we had 3 panels, Central, East, and West panels. I just make a note that South was not represented as a panel. I felt lucky to be placed in the panel led by Justice Mendonça as its president. He set targets for the disposition of matters and was always available to engage in discussions and provide guidance about the resolution of complex legal issues. I was able to interact more frequently with this legal giant, and only then did I learn that he possessed a sense of humor and could deliver a well-timed joke, his tell, however, being that he would go red in the face. The theme of Justice Mendonça's presentation is the evolving role of the judge, lessons from the past, demands of the future. This theme surely resonates with all of us in this room and those who are viewing online, and I'm confident that we will be actively listening and meaningfully participating in the ensuing discussion. I thank our Honourable Chief Justice Boodoosingh, who was appointed as the head of our judiciary in October 2025, for giving me the opportunity to continue the work of the JEITT as its chairman until the end of this law term. By so doing, we have been able to ensure that the JEITT is well poised to carry through the vision of our Chief Justice Boodoosingh, that is, to promote a judiciary which is fair, accessible, collaborative, and efficient. The acronym for that vision is FACE, F-A-C-E. And as long as we all remain true and committed to the cornerstones of these 4 principles, as clearly explained by our Chief Justice, then we can be assured of a realized vision that will enable us to overcome the challenges faced by any organization, including the judiciary. Chief Justice Boodoosingh has ensured that our JEITT remains relevant and capable to fulfill its mission of transformation through education. This DJL 2026 is a testament of his commitment to brand our judiciary as one which can withstand the changing times and demands placed on our organization. The almost 9 months I had working with Chief Justice Boodoosingh, he as president of the JEITT, and me as its chairman, has been a great experience because his approach is one aligned with a philosophy of education that is all-inclusive in terms of delivery of lectures and participation. The JEITT, under the leadership of Chief Justice Boodoosingh, true to his collaborative approach, has ensured that the voices of all practicing attorneys at law are heard and their suggestions for a more efficient judiciary are given meaningful consideration. It is now my privilege and honor to welcome our Chief Justice, the Honourable Mr. Justice Ronnie Boodoosingh, to deliver opening remarks and introduce our distinguished Jurist 2026. I thank you.
Thank you very much, Justice Lucky, for your very warm and kind introduction. You will permit me, I hope, to adopt the list of protocol which has been ably established by the chair of the JEI, I hope, and to say to this gathering, a distinguished gathering as it is, a warm welcome to all of you who are here in person and online. I am especially pleased to welcome back our distinguished jurist and many of his colleagues, and in particular, Mrs. Lydia Mendonça. Thank you all for accepting our invitation to attend today, either in person or online on our live stream. I also thank Justice Gillian Lucky and the team from the JEI, the protocol unit, and all those who have worked so very hard to make today's event possible. As I welcome you to this distinguished jurist lecture, our speaker is indeed a distinguished jurist by any measurable standard. If you visit the Judiciary's Webopac, you will see that retired Justice of Appeal Mendonça participated in the delivery of 683 written judgments. This is the largest number of any judge in the judiciary, present or past. This does not include the hundreds of oral judgments which he gave in his long and illustrious judicial career. But participation is one thing. A week does not pass in the civil courts where a judgment of Mendonça J or Mendonça JA is not called in aid to support or refute an argument. His judgments have dealt with myriad procedural questions, such as extensions of time and sanctions. Roland James is probably the most cited judgment ever. They have dealt with test for on a stay of execution, and so many issues which have arisen in the procedural landscape. On the substantive law side, whether it is on land law, or public law, or industrial relations, or commercial law, or a nuanced point on limitation, or on perfection of a judgment, and when can a court revisit an order it has made, a Mendonça judgment is there to provide scholarly guidance to judges and to lawyers. I could do the roll call of his judgments, but I'm confident that this gathering knows his work well, so that is unnecessary. His judgments have been tested by the Privy Council on many occasions, and he has had an enviable record there. All of this happened because of the time and care he took to write a judgment like a true jurist. I recall when I joined the Court of Appeal, I learned important lessons on appellate judgment writing from him. When my drafts came back with lots of red insertions, asking questions, or with suggestions, well, they seemed like suggestions, whether I wanted to add this or that, or to change how something was phrased because it was too loose and maybe inconsistent with what was said in X or Y case in the past. One lesson I learned was you have to tell the full story of the case for the reader, so the judgment is a complete whole, and to demonstrate that you understood the submissions of the parties. He is one of the finest judges we have produced as a nation, and he's one of the finest judges we will ever produce. All of his work was accomplished without fanfare. When he left us, he chose to do so quietly and humbly, because that is just how he is. But today, we brought him back so we as a profession can say a proper word of gratitude to him. And to do that, we gave him work to do. Not only to prepare and deliver a lecture, but also to subject him to questioning after that. Life can be like that sometimes. By way of biography, Justice Mendonça attended St. Mary's College. He attained a Bachelor of Arts degree from the University of Toronto, an LLB from the UWI, and the LEC from Hewarding Law School. He was admitted to practice as a solicitor in 1981 and worked at Denobrega, Innes and Company, first as an associate and then a partner. In April of 1997, he became an acting judge and later took up an appointment as a permanent High Court judge in May of 1999. His scholarship, performance, and diligence was such that he was appointed to the Court of Appeal in 2004, where he remained for almost 20 years before he took early retirement in 2024. During his tenure, he acted as Chief Justice on several occasions. He is also a Fellow of the Chartered Institute of Arbitrators. He is married to Lydia, and they have 2 accomplished children who are well on their way as well. Justice Mendonça is well respected throughout the region. He is a judge's judge. He has been an exemplar, and he's an example to all judges. And he fits the bill, as a most distinguished jurist. I am honored, therefore, to invite him to address us on the topic, the evolving role of the judge, lessons from the past, demands of the future. Please join me in a hearty welcome to Justice of Appeal, Allan Mendonça.
Afternoon, everyone. If I may adopt the Chief Justice's position and treat the protocol list as established and read. And yes, I did leave in 2024 quietly. And if, Chief, you wanted to say something to me, you could have sent me a card or something, you know? But I thank you for your very kind introduction, as well as Justice Lucky. It's an honor and a privilege to be invited to deliver this lecture here today. The topic, as you might have heard, is the evolving role of the judge, lessons from the past, demands of the future. In addressing that topic, definition is helpful. If the question is posed, what is the traditional role of the judge? I believe that most would agree that the historical or traditional role of judges has been an adjudicatory role. They render decisions or judgments in settlements of disputes between litigants who come before them. And there would also be agreement that judges are still asked to perform that role. In those circumstances, the evolution of the judge cannot be seen as anything as dramatic as, say, the evolution of the butterfly from egg to adult butterfly. What evolution in the context of the role of a judge would seem to me to refer to are the changes there might have been, which might have impacted or might continue to impact on the traditional role of the judge, the manner in which it has been performed, and any expansion of the role. The topic seems to assume that over time there have been changes in the judge's role. I believe that to be so, and in the next half hour or so, I will try and touch on some of the changes there have been. In doing so, my focus will be primarily on the civil law side, although I will make passing reference to other jurisdictions. In relation to the criminal side, the references I make might more correctly be described as fleeting. And for that I ask to be forgiven. The fact is that as an attorney, I practice in the civil courts and family courts, or as they were then called, the matrimonial courts. And as a High Court judge, I did not sit in the criminal court. And as a judge of the Court of Appeal, I did not do much criminal work. The truth be told is that I've witnessed one criminal trial from beginning to end. And this was in 1979 when I was an in-service trainee in the chambers of the late Carl Hudson Phillips QC. One of the junior counsel in the chambers was representing a man charged with burglary. He invited me to come along with him to the trial, and I accepted that invitation. The evidence against the accused was that his fingerprint was found on a cash pan in the house he had broken into. His explanation was that he had been apprehended by the police in connection with the offense, taken to a police station, where he was handed a cash pan and asked if he knew anything about it. I see the defense counsel nodded. He held the pan, looked at it, denied ever seeing it before, and also denied any involvement in the alleged offense. But that was his explanation as to how his fingerprint got on the cash pan. And it sounds really plausible, you know. The trial took place before Justice Alcalde Warner, a very experienced judge on both the civil and criminal side of things, and who would later sit in the Court of Appeal. During the course of defense counsel's closing address to the jury, we heard Justice Warner making loud, throat-clearing noises. We looked at him to see that his gaze was focused on a member of the jury who appeared to be asleep and who he was attempting to wake up. The efficiency with which the throat-clearing noises were deployed by Justice Warner suggested to me that that was not the first time something like that had occurred. Long story short, the man was convicted. I have, however, often wondered, in the light of an occurrence such as that, why the option of a trial without a jury in criminal matters was so long in coming. But that's a different issue. But you will forgive me if I don't say much about the criminal side of things. In fact, in view of what I've just said, you should be grateful that I intend not to say much about it. The first and most obvious transformation impacting on the traditional role of the judge occurred as a consequence of the Civil Proceedings Rules 1998. And those rules remain the current rules of court. They brought about a seismic and deliberate shift in the conduct of civil litigation from what existed under the previous rules, the 1975 rules. Under the 1975 rules, the judge is seen as a passive adjudicator, aloof, there to deliver substantive justice on the merits of the case, but having no other active role in the conduct of the litigation. In that adjudicatory rule, the judge in any given case, after hearing the parties, would identify the applicable principles of law, determine the relevant facts, and apply the law to the facts to yield a conclusion as to the rights, obligations, and entitlements of the parties in the case. In many cases, the law is well settled and no cause for dispute. It has been said that in 8 out of 10 cases, finding the facts decides the case. It seems simple enough. However, along the way, the traditional rule of doing substantive justice came to be entangled, at least on the civil side, with an approach or culture to litigation which has often been described as laissez-faire and which undermined public trust and confidence in the administration of justice. This laissez-faire culture meant the judges, though tasked with delivering justice, were not actively enforcing discipline in litigation. The result was a litigation environment where efficiency, timelines, and proper use of court resources were not priorities. Orders for early trial, timelines, and unless orders or orders carrying sanctions, as we may know them today, meant very little, if anything. In short, rules were often ignored by the parties and not enforced by the courts. Many of us who practiced in the 80s and 90s probably have our own recollection that can serve as examples of the product of the laissez-faire approach. A few matters in which I was involved come to mind. I was the instructing attorney for the plaintiff company, a shoe manufacturing company, in an action against the insurers. The company's factory had been gutted by fire, and its claim against the insurers for loss suffered as a result of the fire was denied. An order for early trial was made in 1985 or 1986. The trial eventually began in 1992. Mr. Michael Elabasti, QC, was lead counsel for the plaintiff in the matter. When he became Chief Justice, he referred to the order for early trial as the kiss of death, an apt description as it seemed to be of no effect except perhaps having the matter shuffled more to the back of the pack. The trial of the action went on for 58 days before it was eventually settled, and that was even before the plaintiff's case was closed. It seemed at the time that the completion of the matter was nowhere on the horizon and costs were rapidly mounting. The settlement came 8.5 years after the fire and 7.5 years after proceedings were begun. By then, the company had gone into litigation, receivership, and the result was too late for it. I also recall that there was an application for leave to adduce fresh evidence before the Court of Appeal that was heard over several days. Another matter was an application to strike out a petition for the winding up of a company on the basis that the petition did not disclose a ground for the winding up of a company. Although that application was heard on affidavit evidence only, it took a month of sittings before it was concluded. Today, matters such as those two would likely not take more than a day. Of course, one of the consequences of that approach to litigation was a significant backlog of cases awaiting trial, the extent of which I only became fully aware of when I was appointed a judge of the High Court. In 1999-2000, Chief Justice de Laversit formed a backlog reduction committee, the task of which was to devise ways and means of reducing the backlog of civil cases awaiting trial. I was a member of that committee, and an early decision of the committee was to first consider what should be done with matters that had been set down for trial for more than 10 years, but in respect of which a date had not been fixed for their trial. For those of you who may not be familiar with the procedure for setting a matter down for trial under the 1975 rules, or may have forgotten, I'll try and give a brief summary. Generally, after the close of pleadings, one of the parties, usually the plaintiff, would file a summons for directions. The summons would be heard by a registrar who would direct the place of trial, either Port of Spain, Tobago, San Fernando, depending on where the action was filed, give an estimate of the length of trial, and then give directions for the matter to be set down for trial. That simply meant filing a bundle of the pleadings with the registrar's order and requesting that the matter be set down for trial. This would result in the matter being placed on the general list of cases awaiting trial until it was placed on the cause list, with the proposed date of hearing identified. So when the Backlog Reduction Committee decided to look at matters which had been set down for trial for more than 10 years, but in respect of which a date for trial had not been fixed, the committee was treating with matters which for the most part had not been set down before, had not yet come before a judge for any purpose, but were literally sitting there for more than 10 years awaiting a trial date. On examination, there were literally hundreds of such matters. Perhaps a notable thing, but not surprising in the light of the litigation culture at the time, was that it was only in a handful of matters had an attorney written to the registrar inquiring about his matter and when it was likely that it would be fixed for trial. By then, it was clear that the 1975 rules were not fit for purpose. As Chief Justice Sharma wrote in the foreword to the Civil Proceedings Rules in relation to the 1975 rules and the system it has spawned, and I quote, "What had begun as a new system in 1976, designed to facilitate ordinary persons accessing the courts, had quickly degenerated by mid-1980s into a system fraught with barriers, real and psychological, to access to justice. The common thread running through the several reports on the review of civil procedure spanning the period 1987 to 1997 was that the civil justice system under the 1975 rules had been failing most conspicuously to meet the needs and expectations of the litigants. Undoubtedly, that system was plagued with the triple evils of delay, cost, and complexity, all of which were interrelated and stemmed from the uncontrolled nature of the litigation process. The several reports alluded to above painted a very depressing picture of the civil justice system, wherein delays were endemic and often contrived, and the procedure inflexible, rule-written, and often incomprehensible to the ordinary litigant. The system encouraged an adversarial culture which often degenerated into an environment in which the litigation process was seen as a virtual battlefield rather than the arena for the peaceable resolution of disputes. The natural consequence, therefore, of this litigation was that the expense was often excessive, disproportionate to the value of the claim, and unpredictable. End of quotation. It was accepted that what was needed was a change of the litigation system and culture. It was against that background that the Civil Proceedings Rules 1998 came into being. The rules were drafted with the assistance of Richard Greenslade, a British District Court judge, who was hired as a consultant to work with the Rules Committee. Greenslade had worked with Lord Wolfe, who produced the Access to Justice report following a review of the England and Wales justice system. The Civil Proceedings Rules were greatly influenced by the reforms proposed by Lord Wolfe. They were promulgated in 1998, but because of matters that I need not try and recount, they did not come into effect until September 2005. The Civil Proceedings Rules represent a radical departure from the 1975 rules and have had a significant impact on the role of the judge in the conduct of civil litigation. A key element in Lord Wolfe's reforms was the need for judicial control of the litigation process, as without such control, the litigation process would degenerate into an environment where no rules apply and the result of which was unpredictable delay and disproportionate expense. That philosophy underlines the Civil Proceedings Rules. They are founded on a system of case flow management, whereby the court takes over control and management of the pace and progress of litigation from the parties and their attorneys. Case flow management requires procedural activism on the part of the judge. The judge decides inter alia what procedure is suitable for each case, sets realistic timetables, and ensures compliance. The judge has early and continuous control of the case, by contrast with what the traditional approach in the system had existed under the 1975 rules. The judge exercises his case management powers in furtherance of the overriding objective. Indeed, the Civil Proceedings Rules specifically provide that the court must further their overriding objective by actively managing cases. The overriding objective mandates the court to deal with cases justly. This includes the imperative to save costs, to decide cases expeditiously, using no more than proportionate resources. And that is to say, proportionate to the amount of money involved, the importance of the case, the complexity of the issues, and the financial position of the parties. And to allot to the case a proportionate share of the court's resources while taking into account the need to allot resources to other cases. An overall aim is to conserve resources and consequently to enable more people to access the court. As the Privy Council acknowledged in Bernard and Sibalak, and I quote, "Under the Civil Proceedings Rules, it is no longer right to say that the court's function is to do substantive justice on the merits and no more. The overriding objective adds the imperative of deciding cases expeditiously, using no more than proportionate resources." Under the Civil Proceedings Rules, the judge has a number of powers expressly given to him, which she can exercise in the furtherance of the overriding objective. To mention a few, these include encouraging the parties to cooperate with each other in the conduct of proceedings, identifying the issues at an early stage, deciding promptly what issues need full investigations and trial, and accordingly disposing summarily of the others, making appropriate use of technology, dealing with matters without the attendance of the parties, and dealing with matters in written instead of oral submissions. These are all powers given to the judge with a view to achieving an early and amicable settlement of a matter. The judge may encourage the parties to use the most appropriate form of dispute resolution, including, in particular, mediation, if the judge considers that appropriate, and facilitating the use of such procedures, and can also actively encourage and assist parties to settle a whole or part of the case on terms that are fair to each other. The civil proceedings rules also expressly attach sanctions for non-compliance with some of the rules, and in respect of others, the judge may impose a sanction. This encourages compliance with the rules and orders of the court. The effect of the civil proceedings rules is that substantive justice must now be delivered in accordance with the procedural values of equality, efficiency, cost-effectiveness, expedition, and proportionality, as required by the overriding objective. As the Court of Appeal observed in USA against Jack Warner, justice is not distinct or superior to the overriding objective. Doing justice under the civil proceedings rules is to enable a case to be dealt with justly in accordance with the overriding objective. Thus, dealing with cases justly is put on the same plane as substantive justice. It is not distinct from procedural justice. In the Court of Appeal, the case of Magistrate is Caesar against BS by his next friend Karen Mohammed. The Court of Appeal expressed the view that the new role of the judge mandated by dealing with cases justly included keen attention to procedural justice. The court identified 4 cardinal principles to be adhered to. It stated, and I quote, "It is important to also point out that post-1998, and consistent with the constitutional values of equality, fairness, respect, and dignity, the new role of the judge mandated by the imperative to deal with cases justly includes keen attention to procedural fairness. Thus, respect, equality of treatment, and fairness must now color all aspects of judicial behavior, both in court and throughout the management and hearing of all aspects of a matter. In concrete terms, there are 4 cardinal principles to be adhered to. 1, judges must be fair and experienced as such in all aspects of interaction with litigants and their attorneys. 2, judges must treat all litigants and their witnesses, including attorneys and court staff, with utmost respect, having regard to their inviolable human dignity. 3, judges are obligated to take care to ensure that parties clearly understand both what is to be expected as well as what is actually happening in court proceedings. And all orders, directions, and decisions must be carefully explained so that parties fully understand them and appreciate the consequences. And 4, judges must permit parties to have a voice, that is to say, a meaningful chance to actually participate in their matter at all stages of the proceedings. This further underlines the significant shift in the role of the judge brought on by the civil proceedings rules. The orders in that case, that's Ayers and Caesar case, the Caesar case and BS, were set aside by the Court of Appeal. The court having found that the judge failed to properly explain the orders he intended to and did make and give the party a meaningful chance to participate. But the observance of procedural justice has broader implications. Procedural fairness is a critical driver of public trust and confidence in the administration of justice. It emphasizes that litigants are more likely to accept unfavorable outcomes and respect authority if they feel the decision-making process is fair, applied equally, and they are treated with respect and dignity. Its observance is therefore of significant importance. In the JEI publication, Procedural Fairness, a Manual, the authors identify 9 elements that must exist for users of the court to experience procedural fairness. These are stated to be voice, respectful treatment, neutrality, trustworthy authorities, accountability, understanding, access to information, availability of amenities, and inclusivity. Whether any of these represent an addition to the 4 principles identified in the A.M. Caesar case, just referred to, is not something I need to consider here now. But in view of the importance of procedural fairness, they ought to be borne in mind. While these are significant changes brought about by the civil proceedings rules, they may lose their significance and impact in any discussion of the involving role of the judge. If the cases are not viewed through the lens of public service, the civil procedure framework introduced by the civil proceedings rules not only altered the traditional role of the judge in ways I've attempted to describe above, but welded a public service mindset directly onto judicial office. As I mentioned, the civil judge is now mandated to deal with cases justly, and as we have seen, that entails not only considering the litigants in the case at hand, but the judge is now required to look beyond the litigants to the wider public. Judicial considerations now include making appropriate and proportionate use of court's resources so that more people may have access to the court. The judge is required to make decisions which prioritize matters such as proportionality, allocating to the matter an appropriate share of the court's resources, among others. The judge must do that not only with respect to the litigants before him, but for the benefit of the wider community. The judge is, in essence, the custodian of public resources. Seen in that context, questions as to what are the real issues in the case, deciding with those issues that need full investigations and disposing summarily of others, encouraging parties to cooperate and actively encouraging and assisting parties to settle a whole or part of the case, and a host of other considerations take on a different complexion. And like every person who is entrusted with the use of public resources, the judge is accountable, and accountable not only to the litigants before him or her, but through the Chief Justice to the wider public. So that when concerns are raised as to outstanding judgments or the delay within the judiciary, there's a duty not only to account directly to affected litigants or those who may have asked about it, but to the wider public. Seen as a public service, the judge is no longer merely a legal scholar waiting at the end of the finish line, or an umpire of the cricket match who only responds when an appeal is made, but a proactive custodian of public resources whose duty it is to guide disputes towards the most proportionate, affordable, and expedited settled resolution possible, among other considerations. That is a profound change from what transpired prior to the civil proceedings rules. The concept of public service applies not only to the civil arena, but to the other jurisdictions to which I'll refer shortly, where rules with a similar ethos as the civil proceedings rules have been applied. The changes in the judge's adjudicatory rule were introduced in other jurisdictions as well. In fact, in family matters, you could say the change began there, as rules of court with a similar underpinning as the civil proceedings rules were introduced earlier in relation to family matters. Family matters prior to the current rules, the family proceedings rules, were governed by the matrimonial causes rules, and they fared no better under those rules as the civil matters under the 1975 rules. In the opening of the 2003 to 2004 law term, Chief Justice Sharma in his address described the state of affairs in relation to family matters in these terms. Over the years, experience has shown that the matrimonial causes rules which underpin the Matrimonial Proceedings and Property Act had fallen woefully short of the intended objectives. Instead of promoting conciliation and settlements in the family unit, matters turned out to be bitter, hostile, and acrimonious. The adversarial approach used by the lawyers in the civil courts and adopted in the matrimonial courts did nothing to improve the situation. On the contrary, it made matters worse. He continued, the real disputes between the parties were often lost in legal entitlement and high posture in between their lawyers, which often infected the parties. Matters worsened over the years. This was evident particularly in the Port of Spain Matrimonial Chamber Court, where a wait of 4 months was the average waiting time before a matter could even become for a first hearing, or whether a matter had to be adjourned to another day. Obviously, this was unacceptable, and despite my rostering an additional judge to this court, matters have not really improved. Further lengthy matters kept on being adjourned time and again before they could eventually be made ready for trial, or before the court could find the time to deal with them. End of quotation. This is really no different to what was occurring on the civil side. In that atmosphere, the family proceedings rules were introduced to replace the matrimonial causes rules. The family proceedings rules were also drafted with the assistance of Greenslade, but did not come into effect until January 2004, about a year and a half before the civil proceedings rules. They apply to family matters in the family court, which began as a pilot, but is now an established court pursuant to the provisions of the Family and Children Division Act. The family court is a specialized court with jurisdiction in all family matters. Judges who are assigned to that court are persons who, by reason of their special training, experience, and temperament, are suitable to adjudicate in family matters. So far as is relevant to this topic, the family proceedings rules mirror the underlying principles inherent in the civil proceedings rules. They were designed to wrest control of the process from the attorneys and the parties and place it in the hands of the judge. Under the rules, it is the judge's responsibility to control the litigation process. The judge is mandated to actively manage cases in furtherance of the overriding objective, which is tailored to family matters and includes similar considerations as the civil proceedings rules, namely expedition and proportionality, but importantly, also expressly includes encouraging settlement of any disputes by negotiation or mediation or other means. This recognizes that family matters will benefit from a less adversarial approach. Briefly, in relation to criminal matters, the applicable rules are now the Criminal Procedure Rules of 2023. They replace the 2016 rules. To make the point I hope to make, I will only refer to the 2023 rules, and those rules provide that the overriding objective is to deal with criminal matters justly, and that it is the duty of the parties in the court at every stage of the proceedings to further the overriding objective. The rules set out what dealing with a criminal matter justly includes, and among them are considerations of dealing with a matter efficiently and expeditiously, and allotting to a matter an appropriate amount of the court's resources, while taking into account the need to allot resources to other matters. The rules make it clear that the court must further the overriding objective by actively managing the case. Several powers that the court may exercise in the management of the case are set out in the rules. They make the point that active case management continues for the duration of the matter. Of note is that the criminal procedure rules provide as a general rule that the Court of Appeal shall fix a date for an appeal management conference for the management of an appeal. in furtherance of the overriding objective immediately upon the filing of a notice of appeal. There are no similar provisions in the civil proceedings rules or the family proceedings rules, but the judges do have power to manage civil and family appeals. To be frank, however, the management of an appeal was not at the top of the list of matters to be done in the Court of Appeal. My understanding is that that is now changing in relation to civil and family matters. There may, however, be some benefit in encoding that responsibility. However, for the purposes of our talk today, the importance of the civil proceedings rules, the family proceedings rules, and the criminal procedure rules is that they affected a fundamental change in the role of the judge from passive and aloof to being actively engaged in the management of the litigation process. Any discussion of the evolving role of the judge cannot avoid mention of the Children's Court. This court began as a pilot with the launch of the Juvenile Court project in 2014 and emerged as a Children's Court with the passing of the Family and Children Division Act, which was proclaimed in 2018. That act established the Family and Children Division of the High Court, which consists of the Family Court and the Children's Court. Insofar as the Children's Court is concerned, it is a specialized court with jurisdiction over children matters. Judges who sit in that court are those judges who, by reason of their special training, experience, and temperament, are suitable to adjudicate in children's matters. The applicable rules are the Children's Court rules. The overriding objective of the rules is to enable the court to act in the interest of justice and to promote a children justice system that will deal with children matters justly, provide for the treatment and rehabilitation of child offenders, enable child offenders to live responsibly and productively, promote accountability for violation of law, and protect the community. The court is mandated to further the overriding objective by actively managing cases at each stage of the proceedings, from commencement to termination. Children matters include matters where a child who is defined as a person under 18 has been charged with a criminal offense. Chief Justice Archie, in his address to at the ceremonial opening of the 2016 to 2017 law term, explained the philosophy of the court in relation to such matters in these terms, and I quote, "The philosophy takes into account something that as adults we all know, that adolescents do some crazy things, and that most of them, given guidance and an opportunity to develop and mature, will not continue to reoffend. Empirical research suggests that appropriate interventions, prospects for successful rehabilitation are better for young offenders." Key to putting in practice the philosophy of the court is that while custodial sentences remain an option for children guilty of offenses for which they have been charged, the Act offers several alternatives that are rehabilitative in nature, including counseling, court-annexed peer resolution, which is a process whereby the court requests a group of trained young volunteers to recommend sanctions for children who have come before the court for minor offenses. Children drug treatment process. This process is for children with drug-related offenses who are in need of treatment. And a life lessons program, which is designed to provide children with the skills and values needed to help them overcome life's challenges. The court usually consults with service providers in designing appropriate non-custodial rehabilitation plans. This is a very different court and is a profound and much needed change from the traditional treatment of children who find themselves on the wrong side of the law. Other procedural changes in the civil courts have impacted on the role of judges, such as witness statements taking the place of oral evidence in chief, which demands more meticulous preparation by the trial judge. So too, the predominance of written advocacy over oral advocacy, encouraged by the use of written submissions, have changed the approach of the judge. The pandemic drove judges out of the physical courtroom and into a virtual space, and replaced in-person hearings with virtual hearings. During the pandemic, that was justified as necessary on grounds of public health. The pandemic is now behind us and public health reforms have receded, but virtual courtrooms and hearings remain. What was originally explained on grounds of public health are now explained on the basis of convenience. But necessity also remains, as there is not adequate physical space. Virtual hearings appear here to stay and have redefined the judge's function from physical courtroom manager, now demanding new skills and technological literacy. But these considerations that I have referred to, as fundamental as they are, touch and concern the role of the judge as they relate to the adjudicatory role and function of the judge. To focus exclusively on that, however, would not capture all aspects of the evolving role of the judge. With reference to administration, judges have for long played a role in relation to the administration of the courts. In the Court of Appeal, judges have for years prepared the roster of judges for the approval of the Chief Justice. The same applied in the High Court before the civil proceedings rules. Since the introduction of the rules, the following committees have emerged. The Collaring and Case Management Committee. When the civil proceedings came into effect, a docket system was introduced in the High Court, and cases are assigned to individual judges of the High Court by random assignment using an automated system, which is vital to the smooth operation of the civil courts. This system is overseen by the Calendaring and Case Management Committee. The committee comprises 3 judges selected by the Chief Justice, one of whom chairs the committee. Its functions and responsibilities are set out in an internal practice direction. The overarching function of the committee is to ensure that the case assignment system is administered in such a manner that all judges of the High Court shall be assigned substantially an equal share and kind of work over time. The committee has the responsibility to supervise and rule upon problems relating to the assignment of cases under the system, including but not confined to any efforts to restrain or avoid the enforcement or application of the directions contained in the practice direction. The committee is also responsible for the redistribution of matters where that becomes necessary, such as in circumstances where judges must recuse themselves or where cases are to be transferred to meet related cases before another judge. The chairman of the committee is responsible for the preparation of the emergency roster as well as the preparation of the roster of judges for long vacation for the approval of the Chief Justice. The Judicial Research Council Management Committee. This committee is headed by a judge and assists with the workings of the Judicial Research Council program, in particular the recruitment and assignment to judicial officers of Judicial Research Council, their supervision, mentoring, and training. My information is that there are currently 76 Judicial Research Council, and there's the intention to hire several more. Judicial Research Council support judges by inter alia conducting legal research and preparing memoranda. The Vacation Leave Committee. A cadre of judges sits on this committee. Its primary responsibility is the coordinating of leave so as to ensure adequate judicial coverage during vacation periods. This is not intended to be an all-inclusive list. The fact is that over years, judges have played important non-judicial roles, supportive of the administration of justice, and continue to do so. Then there is the judicial education of Trinidad and Tobago. The Institute plays a critical role in strengthening judicial competence, competency, and modernization through continuing judicial education. It is headed by the Chief Justice as President and a Court of Appeal judge, currently Justice of Appeal Lucky as Chairman. Among the many tasks undertaken by the Judicial Education Institute is the provision of training for judges, masters, magistrates, and court staff. Between July 2024 and December 2025, judges conducted numerous training sessions on a number of topics, including judgment writing and docket management. Judges also administered orientation programs for masters and registrars. Well, what lessons have we learned? And procedures and systems need to be kept under review. The 1975 rules introduced what was intended to be a new system designed to facilitate access to justice and improve efficiency, but by the mid-1980s it quickly degenerated into a system that was not fit for purpose. It was to be another several years before a new system was introduced. The fact is that the 1975 rules were in themselves seen as reformative, and what that tells us is that reform is never final. Secondly, courts exist for litigants, and one size does not fit all, as was found in relation to civil courts for family matters and criminal courts for young offenders. Be on the ready to look beyond the traditional. Also be receptive to new systems and technologies where they can assist in the performance of the judge's role. Be mindful that justice must not only be done, but must be seen to be done. That's the importance of procedural fairness. Looking ahead, I'll refer to two matters. First, one question that may be asked is whether the civil proceedings rules is meeting expectations. Of course, nothing in the civil proceedings rules was meant to alter the judge's obligation to dispose of the business of the court promptly, and in particular to render judgment and reasons efficiently, fairly, and with reasonable promptness. That remains the judge's duty and obligation. It is not by chance that the vision statement of the judiciary is to provide an accountable system in which timeliness and efficiency are the hallmarks while still protecting fairness, equality, accessibility, and attracting public trust and confidence. Indeed, not only are the civil proceedings rules not intended to interfere with that obligation, but it was meant to promote it. The rules held out the expectation that a large percentage of matters would be settled very early in the process, which would otherwise have gone to full trial. The ripple effect of that was said that parties would save time, that huge trial costs would be saved, and the resources of the court would be spared for more effective use. At the time of the implementation of the civil proceedings rules, it was mooted that 1 year to 18 months from the date of the commencement of the proceedings to the date of judgment should be the standard. The question then is, have the rules met the expectation? In the JEITT publication exploring the CPR judge, the authors noted, after consideration of statistics for the years 2014 to 2015 and 2015 to 2016, that approximately 42.4% of matters reach trial stage before they are determined. This was actually slightly higher than the figure under the 75 rules for the last 2 years prior to the civil proceedings rules coming into effect. From later available statistics, it does not appear that there has been much change in the matters that reach the trial stage before they are determined. The expectation of an early settlement does not appear to have been realized. A consequence of that is that matters do take longer to be determined. So if such a large percentage of matters reach trial before determination, the reasons for that need to be investigated. As the authors of Exploring the CPR judge asked, is it because of some design defect in the CPR, or perhaps not a sufficient buy-in to ADR, or perhaps some other reason? These statistics also suggest that there are a number of matters that have been in the system for a long time. That too needs to be investigated. And if they do represent a backlog, then steps need to be taken to address that and understand why that has developed. The fact of the matter is the delay erodes access to justice, which in turn diminishes public trust and confidence in the judiciary. Second, I'll just say a few words on generative artificial intelligence. This represents an issue for judges. It offers many potential opportunities in terms of how lawyers work. It can assist in legal research and generate drafts of legal submissions, among other functions. The difficulty is that it can sometimes generate plausible sounding but entirely incorrect legal argument and cite sources that do not exist, fabricate quotes and legal concepts from non-existent sources, or may quote passages seemingly from a genuine source but that do not appear in that source. There have been instances in several jurisdictions where written submissions presented to the court have been found to contain fictitious cases. For example, in the English case of Bandlaw on Solicitors Regulation Authority, a former solicitor attempted to appeal a 2017 decision by the Solicitors Disciplinary Tribunal to strike him off the roll. The High Court dismissed his appeal after discovering he had cited 25 non-existent cases, which he claimed he retrieved from Google without verifying their authenticity. In the US case of Mata and Avianca, Robert Mata filed a personal injury lawsuit alleging that he was injured when a metal servant cart struck his knee during an international flight. Mata's lawyer used ChatGPT to generate a motion which contained numerous fake legal cases involving fictitious airlines with fabricated quotations. Mata's case was dismissed and his lawyer was sanctioned. But not to be left out, in the local case of Next Gen Pathology Services Limited against Duncan, an employment dispute before Justice James, fictitious cases were cited. The learned judge expressed the view that attorneys bear an ethical obligation to ensure that all materials submitted to the court are authentic, properly sourced, and reliable, and that the citation of fictitious cases was a serious breach of professional responsibility. As a consequence, Justice James thought it fit to direct the registrar to refer the matters to the Disciplinary Committee for investigation and the determination of whether there was a breach of the Code of Ethics. While consequences for attorneys submitting fictitious sources that are generated by the use of artificial intelligence can be very serious, they can also be so for the judge and the administration of justice. Apart from the personal embarrassment the judge may face, if fictitious sources find their way in the court's decision, that would have a direct bearing on the integrity of the judicial process and a blow to public trust and confidence in the judiciary and the administration of justice. Of course, the problem with fictitious sources is not limited to attorneys' use of generative artificial intelligence. Not surprisingly, some of the cases I've come across involving the citation of fictitious sources as a result of the use of artificial intelligence involve self-represented litigants. The fact of the matter is that litigation can be an expensive exercise, which many cannot afford, but they might be just as capable to use artificial intelligence to assist with the preparation of the case. Thank you. This all places a heavy onus on judges to carefully check the authenticity of sources cited to them. The Caribbean Court of Justice and the Supreme Court of Jamaica, and I was told only recently the Supreme Court of the Bahamas, have issued practice directions regulating the use of generative artificial intelligence in relation to affidavits, witness statements, and other court documents in proceedings, and also with respect to legal research and submissions, and providing for the consequences of non-compliance. The Supreme Court of Jamaica practice direction, and that issued by the Caribbean Court of Justice, are similar in nature. They do not prohibit the use of generative artificial intelligence tools to draft submissions, but puts the onus on the attorneys to carefully check the sources. They provide consequences of failure to comply with the practice direction. In the case of this Caribbean Court of Justice, non-compliance may result in court orders against the offending party, rejection or diminished evidentiary weight of improperly prepared documents or submissions. The Supreme Court of Jamaica practice direction goes a bit further, and it specifically provides that non-compliance with the practice direction may constitute contempt of court and result in the referral of attorneys at law to the disciplinary committee of the General Legal Counsel, or lead to any other sanction the court considers just in the circumstances. I understand a practice direction would be issued shortly, and that should be of benefit to both the profession and the bench. Of course, reliance on submissions of counsel or self-represented litigants without proper verification of the cited sources is not the only way fictitious sources may find their way into the judgment of the court. Judges may use it too, and at least some probably do. The fact of the matter is that generative artificial intelligence can be a useful tool. There are, however, a number of risks associated with the use of it, including algorithmic bias, opacity of the AI system being used, which may pose risk to transparency and accountability, and of course the risk of it producing convincing but entirely fabricated cases, citations, quotes, and legal concepts. Now, despite these risks, there is a place for artificial intelligence in the role of the judge. But one thing is made clear: it must not be used for decision-making. The guidelines regarding the use of artificial intelligence in Canada, for example, issued by the Canadian Judicial Council, put that prohibition as necessary for the independence, impartiality, and integrity of the judiciary. In the preamble to the guidelines, it is provided, and I quote, it is fundamental to the independence, impartiality, and integrity of the judiciary for a judge to exercise the powers of office without undue or unauthorized reliance upon non-judges. Judges hold exclusive responsibility for their judicial decisions. It must be unequivocally understood that no judge is permitted to delegate that decision-making authority to a law clerk, administrative assistant, or computer program, regardless of their capabilities. The guidelines issued by the other courts as well that could serve useful guidance and practice direction on the use of JEITT by judges should be of benefit here. In conclusion, the role of the judge has undergone profound transformation from the days of the 1975 rules. Judges have moved from aloof arbiters to active managers of the litigation process and must manage each case mindful that they do so in the discharge of a duty not just to the litigants before them but to the wider community. This evolution was driven by necessity, the need to combat delay, and above all to restore public trust and confidence in the administration of justice. Judges today are expected not only to deliver substantial justice, but to do so in accordance with procedural values of fairness, equality, efficiency, proportionality, timeliness, and procedural fairness. The establishment of specialized courts, such as the Family Court and the Children's Court, has further expanded the judge's role. In these jurisdictions, judges are called upon to encourage conciliation and promote rehabilitative solutions, particularly for vulnerable groups such as children. Administrative responsibility of judges have also grown, and so too has the role they play in continuing judicial education. These functions underscore that judges are not only adjudicators, but leaders, managers, and mentors within the judicial system. The advent of technology has added yet another dimension. Virtual hearings have redefined the judge's role from physical courtroom manager, now requiring new skills and technological literacy. And now generative artificial intelligence presents both opportunities and risks. While artificial intelligence can assist in research, draft, and administrative support, it must never be used for judicial decision-making. The independence, impartiality, and integrity of the judiciary demand that judges retain exclusive responsibility for their decisions. Looking ahead, the evolving role of the judge is one of balance, balancing substantive justice with procedural fairness, balancing efficiency with accessibility, balancing tradition with innovation. Above all, it is about the safeguarding and providing public trust and promoting public trust and confidence in the judiciary. In that regard, it seems that the more things change, the more they remain the same. Thank you very much.
I just want to say, can we say it again for distinguished jurist lecturer this year, retired Justice of Appeal, Justice Allan Mendonça. Justice Mendonça, I know you were not probably around when I was looking, because you are obviously looking younger than I am. But there was this show that really drove me to be even more interested in law. It was called The Paper Chase. And many of you are nodding, so you're around 59 years old. Good. And in The Paper Chase, the professor, whenever he spoke, everything that dropped from his lips, all his utterances, you would see the students in the class writing it. And not because it was going to come in examinations, but he was teaching them philosophy. He was teaching them ethics and understanding. And as usual, if I might say, Allan, your presentation this afternoon was thought-provoking, thorough, and comprehensive. It has given us so much to think about and talk about when we come back from the break. I want to let you know that we have a full house here in the convocation hall. Nobody here had to be begged to come in. In fact, we reached a stage where we were thinking of charging people to come in because many people asked, would they be able to come even though they hadn't registered? And I was taking the opportunity while you spoke, Judge, to look at everybody, their facial expressions, and everybody was just in rapt attention, listening to everything you said. So please, a tremendous round of applause I ask you for again for a brilliant, brilliant presentation. I thank you in advance, Justice Mendonça, for giving us the intellectual property to what you have presented. I will not ask you for your copy that you read from unless you would like to just give it to me. Your wife has said yes, so when Lydia says yes, the answer is yes. Lydia said this, she said, give it to Jillian. And she's confirming that by nodding her head. And I will ensure that with your kind leave, Chief Justice, this is of course placed on our website so that everyone, those who are intending, we have persons near 100, Allan, who are online, who couldn't come this afternoon, who are following, but at least it would be there for public consumption and understanding. At this point, I just want to let everyone know that we are moving swimmingly. We take a break now, a 15-minute break. During that time, of course, you can use the facilities, stretch, get an opportunity to interact with people you probably haven't seen for a long time or just saw as recently as this morning in courtrooms. We come back in exactly 15 minutes, which is at 20 to 7. And when we come back, that's when we will have our Honourable Chief Justice engaging with our distinguished jurist lecturer based on questions that you all would have furnished us with. So during the break, you got your pieces of paper, correct? And if you don't have writing, we have devices, we have pencils. You heard Justice Mendonça speak about traditional methods. We do have pencils available. Baskets will be passed around. It is not for you to put money. It is not a collection. Just please put your questions. Most important, if your question is not asked, please don't appeal or ask whether, what process was used to choose, because I can assure you that whatever questions are not answered, but we have, I am sure our distinguished jurists would not mind addressing it sometime thereafter, after the FIFA Football 2026 is completed, and hopefully with Wimbledon not coming in the way of your time to just, answer these questions. So as I said, 6:25, 15 minutes is our break. We will be passing around for your questions, and when we come back, we go to that very exciting exchange where we have a conversation between our Honourable Chief Justice and our distinguished jurist lecturer. So a round of applause again. And during the break, and I can just say this now, please, I know there's a vote of thanks, but our panelists who played the national anthem, anybody who plays the pan will tell you, the national anthem is the most difficult, not just because of the melody or the notes. You can't afford to make a mistake when you play the national anthem. And I really think a round of applause ought to be given to Mr. Darrell Reed, our panelist. Played perfectly, and he will be entertaining us during the break. So I thank you very much again. See you promptly 15 minutes from now at exactly 20 to 7. I thank you. And as we get ready to restart, could I ask everyone to please return to your seats? And as we do so, could we please give a loud round of applause to our panelist, Mr. Darrell Reed. We'll be hearing more from Darrell later this evening. Okay, we ask everyone to please take your seats.
Two.
Your wife gave it to me.
I have to take this.
You won't need it right here. All right, so if I might just indicate, we got lots of questions. Some came online, some came from your writing. Some of us need to go to writing classes, more specifically penmanship. We did take a long time for some of the questions to understand exactly what was written. But we thank you, of course, for your enthusiasm. Now, we would not be able to answer all of the questions submitted to us, but as I promised earlier, we are going to address them, and when we put the script of what was presented to us by our distinguished jurist lecturer, we'll also answer those questions. Is that okay with everyone? Yes, if you said no, there was no other option. Anyway, all right, so we are all back in the room. And what we are going to do now is have a conversation taking place between our Chief Justice, the Honourable Justice Ronnie Boodoosingh, and of course, Justice of Appeal Mendonça, retired. And this conversation, of course, is based on questions put forward. I hand you over now to our Honourable Chief Justice, who of course will be engaging in the conversation. Could we give them a round of applause as we start this part of the evening's proceeding? Just to give everybody a chance to settle.
I know you came to hear from Justice Mendonça, but at least somebody has to ask the question, so you have to give me a mic that works here. I concur, Julian, with the handwriting course, so JEI next. Next one is penmanship. Right, so we have lots of questions here. I don't know that we'll get through all of them. Can I call you Allan for this segment? It might just make it easier. Right. So, all right, so let's start with an easy one. From a personal point of view, how did you have to change your lifestyle to fulfill your role as a judge? I think that's Judge Past. That's part of the past lecture.
Yeah, well, for me, it wasn't much of a change. I live a very conservative lifestyle. I didn't try purposefully to extend my circle of friends, so it was limited in that respect. And I did so really deliberately. But other than that, no real change was required. I mean, the fact is that judging is a full-time thing. I can't think of a day that I didn't take home work with me. I can't think of a holiday that I didn't take at least a file with me. And before things became paperless, the file would usually end up in my wife's suitcase, But that, so you just learn to deal with that and make the best of it. But that is what you need to do. You need it as a judge to adapt. But that in itself was not was not really a change for me, because working where I worked, I always had a heavy workload. So it was really just a continuation of it in a different sort of format. And I don't think, even though we were, you have 4 weeks or 6 weeks vacation, I can't recall leaving the country for more than, say, 2 to 3 weeks at any one time. At least not for a while after I became a judge.
Okay. All right. So, in terms of the theme that you talked about, you spoke about the movement of the judge as a passive adjudicator to judicial control, active management, and you traced that process. And then you spoke about 9 principles. I was writing quickly, I got 7 of them. But voice, respect, neutrality, trust, accountability, access, inclusivity, and so on. How does a judge now prepare for all of these responsibilities that pass upon? How do you prepare? What should training look like for judges or persons who want to come on the bench?
I think the judge has to be mindful of that. I mean, has to be mindful of that, and it's really, I suppose in a given case you're interacting with the attorney if the person is represented, but you have to know that behind the attorney is the client, is a litigant or a live litigant. And you do what you can to see that the person has a fair hearing, and that is basically the essence of it. That that through the act, you're corresponding with the attorney, or your interaction with the attorney is respectful, that you're listening to his case, that so that the person leaves there thinking that they have a full hearing, they have a proper hearing. As far as the training is concerned, I mean, I think the requirements, so to speak, for themselves as to what is required. And it's sort of inherent in any judge's duty to give somebody a fair and respectful hearing. I mean, and sometimes you have to, I suppose, check yourself if you get overly frustrated as to if, depending on the things being said in court, the submissions made, the refusal of counsel to take the hint that he's not being very logical or making any sense, but you just try and be respectful as much as you can. I think that will go a long way to letting the litigant know that they have had some, that fair hearing, that they have lost the case, but they had a good shot at it.
Right. Now, had a good shot at it. Sometimes it might be in theory until they get to Facebook. Yeah. So that leads to one of the questions we had about, should judges engage more with the public, or is judicial silence still the better course?
You mean while they are adjudicated?
While I suppose after they've adjudicated.
No, well, my position on that would be no. I've never done it.
Okay, so
You know, Randa, you know, there was an instance many years ago where the judge had refused, I think, can't remember the exact circumstances, but between one adjournment to the other, the spouse of the litigant passed away. And he felt so moved by the circumstances, he actually came down from his chair and embraced her. You know, so but no, I think we have to. There's a line we draw. You know.
all right, so a follow-up from that, it follows that, well, how can the judiciary strengthen public confidence in an age of instant criticism and social media? How can the judiciary do that? Because silence, yes, easy answer, but how can the judiciary as a whole deal with it? Or we just
I don't think
take it as it comes?
you can't stop the criticism. What you could do is do the best to ensure that it doesn't come. You know, by taking the steps that the Court of Appeal suggests. So the whole aspect of fairness, procedural justice, and that type of thing. So do the best we can to again, so it will come across. So at least that you are invested in the case, that you haven't dealt with it in a very offhanded manner, or so on.
Okay.
I think, but the easiest thing nowadays is to pick up the phone or go on Facebook and say something. I don't know. You can't really stop that, and I suppose someone who is not successful, the first reaction would be one of disappointment. Or so, I guess so. You have to, and that person may vent it in a variety of ways. So I suppose you just do the best you can to ensure that person feels that they have been treated fairly.
Okay. Now, one of the themes you talked about is the judge's accountability and the accountability of the Chief Justice or the judiciary as a whole, having regard to the use of public resources. In that context, how do you feel about performance standards and KPIs for judicial officers? Key performance indicators. And performance standards being established. How do you feel about that in the context of your point about accountability of individual judges and the judiciary as a whole?
I'm not really sure how that will work. Right. You know, I don't really understand what that. Or is it that what they will be graded? Or?
Well, some sort of benchmarks, for example. Should we set benchmarks for judges? Hours of sitting. Should we set disposal rates? Should we set guidance in terms of fairness, how cases are conducted?
Well,
those kinds of things.
Matters such as that, what constitutes procedural fairness, what those type of matters, those can be, you can deal with those in terms of training. Right. But in terms of setting standards, in terms of how long they sit, and so I don't know where that will get you. I mean, the aim today is to reduce as far as possible the number of hours you sit. I mean, it's not a clear indication as to the fact that you are in court 2 hours doesn't mean that you are not working for 8 hours after that, or doing whatever you can. So. I don't know how you will track that. The judges work differently. So
there are lots of murmurs here. So there's either agreement. There seems to be some. You've hit a chord there.
Yeah. For example, the average appeal, for example, may take less than the afternoon break, let's say. A lot of appeals would be finished by lunchtime. but you then take into account the many hours you said reading a record that may be a few hundred pages long and things like that. So,
See the Court of Appeal clapping. All right. So, one of the points you mentioned, and in fact during the break, one of the attorneys was talking about and you mentioned it in relation to cases in the past, the various rules, in a sense, address backlog. But what happens when those rules are now working, but a fresh backlogs are being created, whether it's family, civil, criminal, I mean, throughout the system? What do we now do?
Well, that is something that from the, and I don't know, has the judiciary stopped producing statistics or posting on the site, because they're not easy to come by. But the latest statistics I've seen just suggest that there's a possibility of a backlog accumulating several thousand files. And now whether it represents a true backlog, there may be matters that have started that have just stayed there and, didn't reach the stage of a defense, so it never got before a judge, that kind of thing. So I mean, those figures need to be interrogated. And if they do represent a backlog, well, then you need to understand why that is. I mean, is it that there's some design in the rules, that insufficient use of the case management powers that the judge has? Is it that we need to do more about some sort of alternative dispute matters? But it's difficult to get people to buy into ADR. And in a lot of cases, they just view it as an additional expense that may achieve nothing. And certainly when it, in the Court of Appeal, for example, 2 years ago, we had this exercise to try and get on top of a number of appeals that were there for a number of years. And before that, we had experimented with doing some sort of ADR in the Court of Appeal, and with the participation of some judges who were trained in mediation, we tried to get people to attend, to do some mediation in these matters that were pending in the Court of Appeal, but there was a low take-up on that, and because they were sitting on a judgment, so that makes it even more difficult. So if you're going to engage in ADR, is to try and get the buy-in, and obviously at some level below, if you make it mandatory, then you're looking at a whole different set of expense and who's going to pay for that and that sort of thing. So it has to, it may be that some form of alternative dispute resolution is probably the only way you're going to deal properly with those matters if they do constitute a backlog.
As you've mentioned mediation there's a question on the role of the judge in judicial review cases as far as mediation is concerned. In matters where the vires of a decision is an issue, or where the law needs clarification for the public, does an insistence on exploring mediation undermine the High Court's supervisory jurisdiction and or inhibit jurisprudence?
Well, I mean, there obviously will be some cases that are entirely not suitable for mediation, and those cases that have some precedential value well may not qualify. But outside of that, if it's a decision as to say whether they are running when I say running the mill, that there have been many cases that deal with, like say a promotion case. By now they probably deal with almost every aspect of that. Then there's no harm in trying to resolve those type of cases outside of the adversarial system.
Right. And this follows as well about the point you made about the Court of Appeal. how far should the judges of the Court of Appeal go in trying to encourage settlement on the morning that an appeal is listed for hearing? And how realistic, sounds like there's a story there, how realistic is the prospect of settlement when one party already has a judgment in their favor?
Well, I just touched on that. It's very difficult.
Yeah.
But if on the morning of the matter, it becomes even more less of a chance that the matter would be resolved. But the thing is that is really, unfortunately, when the judges get a proper understanding of it by preparing the night before. So if there is or the days before, so if there's some obvious point that appears to all the judges, this is a knockout blow, as they say. Right. Well, then you can put that to the parties and see if they agree. Sometimes, very rarely they do, but the thing is sometimes they do. Other than that, you do have the problem with a judge sitting with one party sitting on a judgment, and they're not going to surrender that position easily. What has happened in the past is that a lot of appeals are really fact-driven.
Right.
And what is dressed up as really an attack against the judge's judgment on some question of law, when you really study it carefully, it becomes a question is was a challenge on the facts. And it seems now that that is an extremely difficult kind of appeal to mount. Even where a judge may not refer at all to the evidence, and try and explain all the evidence at all. What the recent decision of the Court of Appeal, you have to look at the judgment with a degree of charity. Now, so the appeals on questions of fact have become very, very difficult, and probably with a proper persuasion you can get the attorney to agree to that. I mean, to see that. Whether that can be done prior to the actual listing of the matter, that depends on the amount of time that you have to invest in doing it at an earlier stage. Because, I mean, as I mentioned, the fact of the matter is that that case management is not really a thing on the civil side in the Court of Appeal. It was, when the matter came before the cause list hearings, it was really a question of fixing a date and giving directions for submissions. I think that was really, because in a lot of cases it was really not a proper expenditure of time. But I suppose in the appropriate case it could be, especially where it boils down to an appeal from really a finding of fact,
Okay. I want to turn to some of the points you made on the use of artificial intelligence.
Mm-hmm.
And there's this question, will artificial intelligence transform judging, or will it merely assist judges?
Well, it could be both. It should, well, I gather from what you cannot leave it to them. You leave it to the system to arrive at the decision. There was an article I read with an interview by a few judges, a dozen or so, and they said they all admitted to the using artificial intelligence, but some refused to use it before they had arrived at a decision, and used artificial intelligence as a sort of a check of what they had arrived at. But if you accept that you should not leave it to an artificial system to arrive at a decision, then you have to satisfy yourself. But you do use it. You have to satisfy yourself with anything that is said. You arrive at it through your own researches, and through your own application of whatever you find and what your interpretation of the evidence is. So it is a tool, but the general understanding is that it should not be used for decision making, and you need to adhere to that as a judge. Try and work with it, but don't leave the decision to the system.
Fair enough. Would you say that the role, coming to the end of your talk, you said, well, in effect, the more things change, the more they seem to be the same in a sense. Has the role of the judge changed, or has society's expectation of judges changed?
No, I think that there is a definite change in the role. I think more is expected of judges, but I think the normal and expectation of persons outside of the general public is that the judges will get on with the judging, not to adopt any other role. Their main interest is that they have a dispute, what they would like to have settled, and I don't think they really care too much for the fact that the judge may do a variety of other things. That the main thing is that they come to the court to resolve a real dispute they have, and that's the main focus of the litigant.
So we're going to change approach a little bit. Now, all of these demands on judges, the call for judges to do more, perform more, society's expectations, and with the continued demands of the role of the judge, do you think judicial wellness should be regarded as an essential judicial component rather than simply a personal responsibility?
I'm going to have to.
This is one for penmanship. Judicial wellness.
Could you repeat the question, please?
With the continued demand of the role of the judge, do you think judicial wellness should be regarded as an essential judicial component rather than simply a personal responsibility? I get the sense that the judiciary should encourage judicial wellness as opposed to leaving it up to the individual judges.
No, I think that's a personal matter. The thing is, we judges fought hard for sabbatical. It remains as an entitlement for judges. I don't think, as far as I'm aware, I'm not sure it has ever been utilized. And so, of course, it's subject to the demands of the court and so on.
You might be opening up a can of worms.
But the thing is, it's there. It was a hard-fought victory. It went to court, even though you could say is us deciding for ourselves. But in fact, there's no other alternative. The judges are the ones that make the decision. But it has remained there as a dead letter for years, although it is a part of our entitlement. And the point about the sabbatical is that if you are sensing burnout or time for a break, there is that option, rather than think of retirement or leaving the judiciary or pivoting or doing something else, take a sabbatical. And you might change, you might have a different view when you resurface.
Well, I think you recovered on the answer there, because before you were not going to get a clap. So we are coming to the end, so I want to turn a little bit personal in terms of the questioning. You've had a very long and distinguished career as a lawyer and a judicial office, and you continue to do things. We're having a conversation earlier with Mrs. Mendonça, who encourages that you to continue to work. Probably, what's the lesson, the single greatest lesson you can give to judges now? Or let's say those of us who are towards the end of our career, but they're the ones who have come in, the new ones, the ones who are there. What is the lesson you will give to them from your experience as, they carry the torch forward?
You have to commit yourself. You have entered a profession or a calling, some refer to it as that is extremely demanding. I don't think there's ever a period of time when you can say you have nothing to do as a judge.
Right.
So you have to have that mindset. Be prepared for the long haul. Be prepared to work long hours. And to do so cognizant of the fact that these are real problems you're trying to solve. It's a very fulfilling role, but you need, if you're not prepared to put the effort in it, then don't bother to come,
And the people who are clapping are the people who are sort of on their way out. That's just saying. Justice of Appeal, retired, Allan Mendonça, thank you very much.
Thank you.
Thank you very much for that very engaging discussion. Just to put everybody's mind at ease, I am mindful that the Chief Justice is my boss. I did not go on my own and hold up those time cards. The Chief Justice asked me to do it because I saw some of you kind of mumbling and saying, oh, look what you're doing. No, it was a request. Not so, Chief Justice?
Very much so.
Thank you. Very good answer. I really want to say thank you very much for that conversation, the discussion. Many of the questions were answered. Some, as I said, still have to be answered. Many takeaways. Big takeaway, to sabbatical or not to sabbatical, that is the question. Many other questions and answers. So again, a round of applause, please, to our Chief Justice and Justice Mendonça. At this point, my role comes to an end, and I just want to say thank you very much again to the audience. Many times after the break, when we look at the convocation hall, there are many empty seats. Give yourselves a round of applause, because I can tell you we still remain full, and that is excellent. And I hand over now to our Honourable Chief Justice. Thank you very much.
So before we have the final vote of thanks, I wish to first say thank you very much to Justice Mendonça for the stimulating lecture this evening and for sharing your perspectives on the evolving role of the judge. I'm sure your ideas and comments have resonated with all of us gathered here today, and we will long recall your sage advice delivered to us this evening. Thank you on behalf of a grateful audience, and thank you for your service. And we have a presentation. The final thing that I would like to do before the vote of thanks is to acknowledge the hard work and the dedicated service of Justice Gillian Lucky to the work of the JEI. Justice Lucky has indicated that after 7 long years of service in the position, the baton will be passed at the end of July to continue the run of the important work of the JEI in the position of chair. She will remain one of our most valued trainers. Gillian has been a live wire in this role. She has, Justice Lucky has led from the front, leading the JEI team into every event with enthusiasm, attention to detail, and shared determination and commitment. Justice Lucky has chaired events with great aplomb, as she did today, bringing all the experience gathered over many years of teaching, administration and education, judicial knowledge, and even in communication and entertainment. Whoever succeeds will have a hard act to follow, but can surely build on the strong foundation that has been laid. Now, Justice Lucky, I am told, does not like surprises. So I am having to take full responsibility for paying this very small tribute this evening to recognize the sterling work, innovation, and leadership which has been brought to the office of chair. I thank you, Gillian, most sincerely for the support you have given me in these past few months. I have asked much of Judge Lucky and the JEI team, and they have delivered with good grace and real commitment. I am sure I also speak for Chief Justice Archie in expressing sincere thanks for your dedicated service. Thank you for your many years of unrewarded service, which has been to the benefit of all judicial officers and to the judiciary as a whole. The Trinidad and Tobago JEI is an example to JEIs all over the Commonwealth, and Justice Lucky has played no small role in ensuring our reputation for excellence has been preserved and enhanced. Thank you, Judge, for your service as chair of the JEI, and we are honored to present you with this very small token of our appreciation for your service to the JEI and the judiciary. And now I will say thank you and hand back to Genevieve Julian.
Thank you, Chief Justice. Ladies and gentlemen, thank you for joining us for this year's Distinguished Jurist Lecture. Your presence has truly enriched the occasion. I now invite Mrs. Kimberly Prescott Acting Registrar and Marshal of the Supreme Court, to deliver the vote of thanks. Mrs. Prescott, a valued member of the JEITT Board, has devoted many years of distinguished service to the judiciary, holding key judicial and administrative appointments across its divisions and registries. Please join us in warmly welcoming Mrs. Kimberly Prescott.
Good evening. The Honourable Mr. Justice Ronnie Boodoosingh, Chief Justice of the Republic of Trinidad and Tobago, and Mrs. Allan Boodoosingh. Our distinguished 2026 lecture speaker, the Honourable Mr. Justice Allan Mendonça, Justice of Appeal retired of the Supreme Court of Trinidad and Tobago, and Mrs. Lydia Mendonça. Now we, in the judiciary, are of course an institution guided by and bounded by precedent. In these circumstances, I can think of no better precedent to follow than that set earlier this evening by the Honourable Chief Justice himself and the distinguished lecturer who adopted the protocols so ably established by the Executive Director and the Chair of the JEI. Accordingly, with greatest respect to all distinguished and esteemed guests gathered here this evening, I too adopt the protocols already established. Having disposed of that preliminary issue, I now turn to the more pleasant task of expressing our heartfelt thanks. It is indeed my honor to deliver the vote of thanks at the conclusion of this 11th Distinguished Jurist lecture. This evening, we have had the privilege of hearing from one of our country's most respected jurists, the Honourable Mr. Justice Allan Mendonça, whose lecture, entitled The Evolving Role of the Judge, Lessons of the Past, Demands of the Future, has challenged us to reflect on where we have come from, where we are today, and perhaps most importantly, where we are going. Justice Mendonça, on behalf of the Judicial Education Institute of the Judiciary of the Republic of Trinidad and Tobago, thank you for accepting the invitation to deliver this year's Distinguished Jurist Lecture. Your address was thoughtful, insightful, analytical, and characteristically measured. It reminded us that while the foundations of justice remain constant, the expectations placed upon our judges and judicial officers, and indeed upon our entire justice system, continue to evolve. You have challenged us to preserve the enduring values of judicial independence, integrity, and procedural fairness and impartiality, while recognizing that the role of the modern judge extends well beyond the courtroom. As you so aptly demonstrated, today's judge is called upon not only to adjudicate disputes, but also to contribute to the effective administration of justice through committee work, judicial education, and active participation in the many initiatives of the Judicial Education Institute. This evolving role demands innovation, accountability, and responsiveness to the changing needs of those whom we serve, while remaining firmly anchored in the timeless principles that define our profession. What many may not know is that this lecture did not begin with your arrival here this evening. It began months ago. From as early as mid-May, you immersed yourself in preparation. You requested statistics related to the number of matters in various divisions over the last 10 years, historical information on the training given to judges and judicial officers, and operational data regarding the number of courtrooms in court buildings, not because you needed to, but because you wanted to ensure that what you shared with us was grounded in fact, informed by evidence, and reflective of the true past and present realities of our institution. In an era where opinions are plentiful, you reminded us of the importance of first seeking the facts. That careful preparation and intellectual rigor is perhaps the greatest lesson of all, and it is what has made this evening's lecture all the more valuable. Justice Mendonça, those of us who know you know that you are quite soft-spoken. In fact, before this session, we made sure the microphone was turned up to the full volume just in case. But while your voice may be quiet, your message came across loud and clear. And judging from the attention in the room, I am quite certain that it did not fall on deaf ears. Thank you for sharing not only your knowledge, but also your wisdom and your experience as a jurist committed to the administration of justice. We are honored that you have added your voice to the distinguished legacy of this lecture series. Of course, evenings such as this do not happen by accident. They are the product of teamwork, dedication, and meticulous planning. Our sincere thanks are also extended to the board of the Judicial Education Institute for its vision, leadership, and continued stewardship of this distinguished program, ensuring that the DJL series remains one of the Judiciary's flagship educational initiatives. I wish to express our sincere appreciation to the President of the JEI, the Honourable Chief Justice, for his continued vision and leadership in championing judicial education and fostering opportunities for thoughtful dialogue. These lectures do more than commemorate distinguished careers. They encourage us to think critically, to question thoughtfully, and to continuously strive for excellence in the administration of justice. I wish to also acknowledge the Honourable Justice of Appeal, Justice Gillian Lucky, Chair of the JEI and this evening's proceedings, whose passion and leadership continue to advance the Institute's important work. I also recognize the Honourable Madam Justice Norala Banzi-Sukai, Deputy Chair, for her invaluable support and dedication to the Institute's mission. A special word of appreciation is due to Ms. Genevieve Julian, Executive Director of the JEI, whose meticulous planning, coordination, and tireless hard work, together with her team, have once again ensured the successful execution of an event of the highest standard. The staff members of the JEI continue to show their collective commitment to judicial education and professional excellence, which enriches not only the judiciary, but the wider administration of justice in Trinidad and Tobago. Events of this caliber are only possible because of the dedication of many individuals working behind the scenes, often without recognition. Our sincere thanks to Mr. Carl Francis and the Court Protocol and Information Unit, whose careful planning and flawless management of protocol ensured that this evening's proceedings reflected the dignity and decorum befitting of the occasion. Deputy Court Executive Administrators Ricab Ali and Jerome Mark for their insight and coordination of the many administrative arrangements required for this event, and to their respective administrative units whose hard work and dedication ensured that every detail was carefully attended to. Ms. Nayola Coker, Court Manager, for ensuring that the Hall of Justice was fully prepared and that every operational detail was in place. The Information Technology Unit for providing technical support that underpinned tonight's program. The Occupational Safety and Health Unit and the Court Security Unit for ensuring that the event was conducted in a safe and secure environment. Office Management and the General Administration Unit for their invaluable administrative and logistical support. The Court Communications Unit for promoting this important lecture and extending its reach to the wider public. the Court Reporting Services Unit for assisting in the preparation of an accurate record of this significant occasion, and the National Maintenance Training and Security Company Limited, whose support helped ensure that our facilities were presented to the high standard expected of the judiciary. To each of you, thank you for your professionalism, commitment, and support. Your joint efforts have contributed immensely to the success of this evening. We are equally grateful to our external partners whose expertise enhanced this evening's experience. Grapevine Limited for the excellent catering, Linzel Events for the beautiful decor, Mr. Darrell Reed for the entertainment, Mr. Matthew Brian Miller for capturing the occasion through photography, audio-visual sonic for ensuring that this lecture reached audiences beyond these walls through live streaming, and Divinity Trading for providing transportation. We thank each of you for your valued partnership. To all our distinguished guests, members of the bench, the bar, the diplomatic corps, Parliament, the protective services, academia, the public service, our justice sector partners, the media, and the wider community, thank you for honoring us with your presence. Your attendance reflects the importance of strengthening the rule of law in Trinidad and Tobago through continued dialogue about the administration of justice. As we leave this evening, I hope we do so not simply with notes from an excellent lecture, but with renewed purpose. The title of this evening's lecture reminds us that while we can learn much from the past, it is our response to the demands of the future that will ultimately define the judiciary we leave for the next generation. Justice Mendonça, thank you once again for your scholarship, your humility, your diligence, and your service to this organization and the nation as a whole. We are deeply grateful. As we bring this evening's program to a close, I warmly invite all our distinguished guests to join us for the cocktail reception, which will be held in the first floor foyer. Our ushers will be pleased to guide you to the reception, where you are invited to continue the conversations inspired by this evening's lecture over light refreshments. We are also delighted that the reception will be accompanied by the musical talents of steel pan soloist Mr. Darrell Reed. Thank you once again for your presence and for contributing to the success of this memorable evening. We wish you safe travels home and look forward to welcoming you to future judiciary events. I wish you all a pleasant evening.
Thank you, Mrs. Prescott. Distinguished guests, we have arrived at the conclusion of this segment of the evening's proceedings. I invite you to stand for the departure of the Chief Justice and Justice Mendonça. You are all warmly invited to the cocktail reception in the Level 1 foyer, accessible via the elevator or the stairwell. Our ushers will be pleased to guide you. Do enjoy the rest of your evening.